Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. I am an advocate. Har Har Mahadev Jai Shiv Shambhu. With the blessings of Almighty in today's class, we will discuss an important topic concerning the defamation. First of all, we have to note down few important points, means the fundamental points concerning defamation. Every allegation, every imputation would not come with the preview of defamation. To constitute the defamation, the ingredients of Section 356 of BNS must be fulfilled. So basically, the provision says whoever means anyone by words either spoken or intend to be read or by sign or by visible representation makes or publish in any manner any imputation concerning any person intending to harm or knowingly or having reason to believe that such imputation will harm the reputation of such person. In that scenario, the person making the imputation would be responsible as per section 356 of BNS. So basically, we could say that every allegation or imputation is not sufficient to bring the person within the preview of section 356 of BNS. The imputation must be first must be published with intention to harm the reputation of the concerned person, means the complainant. I will discuss the important judgment of Honorable Guwahati High Court, which is dated 4th of Feb 2026, wherein the cognizance taken for defamation has been set aside and quashed by Honorable High Court. So, whenever we are having a case against us concerning defamation, we have to consider few important points. Point number one: the police report or the police investigation concerning defamation offence is not permissible. If there is a case for defamation, the proper course is to file a complaint before the concerned court, and the court will take the cognizance on the complaint. So, if there is any police report and ultimately police after investigation file charge sheet concerning offence of defamation, it is abuse of process. We could challenge the proceeding. Number two, if the complaint is filed, the concerned court is duty bound to follow the process of section 225 of BNS. The said section inter alia says that the concerned court has to record the statement of the complainant, and apart from that, the statement of the concerned witnesses produced by complainant is to be recorded. And before taking cognizance, the magistrate is duty bound to hear the accused, means the opportunity of being heard must be given to the concerned accused. If the legal compliances are not done, and if there is any violation of section 223 of BNSS, in that scenario, the proceeding will be void and we could challenge the proceeding. In addition to this, the concerned court is bound to follow the mandate of section 225 of BNSS. It says that if the accused is residing outside the jurisdiction of the honorable court, in that scenario, the concerned court is bound to follow the process of section 225 of BNSS. If there is no compliance, we could have the benefit. In addition to this, the allegations must be specific. If the allegations are general, the allegations are omnibus, and allegations are inconsistent without any corroboration, we could have the benefit. In addition to this, the magistrate, while taking the cognizance, is bound to specify reason. If the order is not reasoned and there is no specification why a case is made out, in that scenario, the concerned cognizance order could be challenged before the court of session by the way of revision. In that scenario, we have to rely on one of the most important judgment of Honorable Supreme Court, titled as Indrajit versus Santosh. Judgment date is 19th of April 2022. Please be noted, the evidences must be produced, means the material, in consequence of which the allegation is that it inter alia defamed the concerned person, must be on the record. If the material is not produced, it is withheld, we could have the benefit. In addition to this, if the defamation is caused by using the electronic device, so in that scenario, the electronic evidence must be produced. In addition to this, concerning the electronic evidence, is a need to comply with section 63 of BSA. In addition to this, the judgment of Honorable Supreme Court, titled as Ram Singh versus Colonel Ram Singh, AIR 1986, Supreme Court, page number 3, is quite important. In addition to this, if the publication is in the newspaper, the concerned newspaper and the editor-in-chief are responsible and they must be arraigned as a party. Sometimes it is seen that the concerned newspaper, its company, its director or CEO are arraigned as a party, but law says that the concerned editor-in-chief would be responsible for defamation. The concerned director or MD or CEO would not be responsible. Honorable Guwahati High Court says when there is no specific allegation against the accused, and apart from that, there is no specification of the involvement of the concerned accused either in telecasting or broadcasting of the consent allegation against the accused. In that scenario, the proceeding would be illegal, liable to be set aside and quashed. So whenever we are going to fight the case from defense point of view, we have to consider all this point so that we could put up an efficient case on the record. See you in the next video. Till then, Jai Hind, Jai Bharat.